Okay, that was very informative. It was highly appreciated, Maake. Um, you started to give us an introduction to POPIA and how we should, how we are able to balance the rights to privacy against, access to information in our work. Also in that regard, you pointed out the 8 conditions that's necessary in order to collect personal information and how we should navigate that. Furthermore, you gave also the sort of the instruction or the condition around how you appoint an information regulator within your information officer, sorry, within the organization and the deputies. So I think that is of great assistance. What I have been asked by our team who's doing this recording is that we take a break immediately. We do have backup systems for this recording, but we seem to have lost Wi-Fi and they just want us. Are we back online? Okay. Sure. Okay. I've got 4 questions from our online audience. Should we handle those 4 questions now with more questions, or must we handle the questions? It's quite sophisticated questions, complicated questions, I think, from the heritage sector. When we have the document in front of us, how do you do a break and then handle it together?
I propose that let's have a 5 minutes break so that I can quickly visit the gents and then we can come and then try to resolve all these questions. It must be noted that I'm not the only one who's going to be answering these questions. All of us in the room are going to assist in coming to a consensus on how we understand this.
Okay, can I then request that we take a break now of 20 minutes and be seated at 11:45. We'll be back here at 11:45. Thank you. And welcome back after that break. It has been communicated to me that our online audience that are also back, and so welcome back to them as well. So we will now proceed with our program. It is now 10:12, and we will now do a presentation or workshop, the act. We will now work through the document. So I would just like to say that our online audience also received the copy of the act, and we're going to page through it. Just something for everyone in this room at the moment that's here. This is the entire act. Now, earlier on, Advocate Maake alluded to sections at the back, tables at the back. Okay, tables at the back that outlines other acts that have to be, I don't know what is the legal term, but they have to be altered, adapted in order to make this workable. Now, in me printing this document for everybody, copy for everybody, I did not print the tables. It was just a table and a list of acts. No, I'll explain now. So I just want to say, Advocate Maake referred to tables earlier, but for the audience, I did not print those tables. It was a lot of tables of different acts altogether, Cyber Crimes Act and so forth, but it has an impact on, it works together with this and so on. But it was not relevant for our discussion, and the amount of paper. So I tried to save on paper. However, when you receive your documents, the online documents, you will see that that document that was sent to you by email has actually got that table, does have the tables on. But just for us here in this room, I never printed it. So in front of you, you've got what's called on the front cover there, Number 4 of 2013, Protection of Information Act 2013. I'll just ask Advocate Maake quickly, just to explain how did we get to today from 2013. Different sections was introduced at different times. Can you just maybe give a brief overview of how that came about? Timeline.
Yes, colleagues, what has happened is that the original act was put together and signed in 2013, but because the information regulator was not established at that time, so that then needed that this body will be established at a certain time and period. Then the time came, the information regulator was put in place, appointments were made, and you know that the information regulator for South Africa, maybe we can get from the audience, whether do you know who is the information regulator for South Africa? I know you all know who's the public protector, but then who is the information regulator? Anyone? Anyone online? Okay, you remember there is one advocate called Pensi Takula, who was the CEO of the IEC, Independent Electoral Commission. She's now the information regulator of the country. And then she was appointed, and a number of other commissioners were appointed, and they had to then start the office, appoint staff, etc., etc. But then after doing that, they then had to indicate which part of the act is in force at a certain period, because that they did so that they can be able to, for example, have enforcement agencies, have committees, have people who will then start now monitoring the compliance with the act. But then last year or a year earlier, in 1 July, then the whole act started to be implemented, but then it was realized that actually the regulator was also not in a position to start dealing with applications. Remember, information we need to section is that put so that they can put in place, and that section started to kick in earlier this year, and now the whole act as it is now in force. Just another ground to this that process and in terms of how you want data came into place, and they issued those number of guidance and guidelines, guide notes as to how each organization or individuals have to deal with any of the aspects that are mentioned and also mentioned in the presentation.
Thank you very much for that, Advocate. Okay, so when we look at this document which I printed, you will see, and I will just explain to everyone how we're going to use this document so that we don't lose each other. If you page through it, you'll see on top there are numbers, and it runs 2, 4, 6, 8, 10, 12. You'll see right on top 14, 16. Can you see that? Okay, so there's numbers missing, but there's an odd number, page 17. There's an odd number there. All the others are even numbers, and there's an odd number there. And I'll tell you, an odd number creeped in there. That's because every alternate number, every odd number is in Afrikaans. So there are there's no numbers missing from this printed copy. So 2, 4, 6, 8, 10, and so on. It's in English. The 3, 5, 7, 9 is in Afrikaans. Okay, so those are the page numbers. Then, if you go to the just anyway in the middle of the document, these bold numbers on the side, and I think the bold ones, those are the sections. Okay, so that we just all understand, because we're going to refer to which to go to a certain section. So from the front of the document, to the back, you will see that those are all consecutive numbers. They run, okay? They all run in sequence from 1 to the end of the document, and those bold numbers are sections. So you will have, for example, if everyone goes to section 30, if everyone can go to section 30 as an example. Then you will see that section 30 is on page 40. Is that all good? Section. Now in brackets there's a 1. That's subsection. Section 30, subsection 1. If you look on top by 28, section 28, I'm so sorry. You will see it's the subsection, section 28, subsection 1. Then there's A, B, C, D, or at least A, B, C. Those are paragraphs. So the bold section, the bold number is of a section, and then the number in the bracket is a subsection, and the alphabetical letters in brackets, those will be the paragraphs. So just so that we all understand, understand each other. Is that all good? Okay. So we'll go back to the first page, or page 2. We'll go back to page 2, or the inside of the front cover, to make it easier, and we'll start from there. I am going to read that whole page to you. It's a very important page. The short title of the Act is called the Protection of Personal Information Act 2013. I will now read the long title. And that's the bold in the middle of the Act on page 2. To promote the protection of personal information processed by public and private bodies, to introduce certain conditions so as to establish minimum requirements for the processing of personal information. To provide for the establishment of an information regulator to exercise certain powers and to perform certain duties and functions in terms of this Act and the promotion of Access to Information Act of 2000. To provide for the issuing of codes of conduct, to provide for the rights of persons regarding unsolicited electronic communication and automated decision-making, to regulate the flow of personal information across the borders of the Republic, and to provide for matters connected therewith. That is the long title of the Act. The preamble says the following: recognizing that Section 14 of the Constitution of the Republic of South Africa, 1996, provides that everyone has the right to privacy. The right to privacy includes a right to protection against the unlawful collection, retention, dissemination, and use of personal information. The state must respect, protect, promote, and fulfill the rights in the Bill of Rights. And bearing in mind that, consonant with the constitutional values of democracy and openness, the need for economic and social progress within the framework of the information society requires the removal of unnecessary impediments to the free flow of information, including personal information. And in order to regulate in harmony with international standards, the processing of personal information by public and private bodies in a manner that gives effect to the right to privacy, subject to justifiable limitations that are aimed at protecting other rights and important interests. Now, that is the important part, shall I say, the purpose of the Act, or the spirit of the Act, why this was proclaimed. And I've highlighted certain things there because of the concern that I raised initially, and I think that is also why we have this workshop, that quite often in terms of compliance, I think we felt that the POPIA Act has been created almost to stunt our work because of all the regulations. But if you read the Act there, the intention of the long title and the intention of the Act, the spirit, it is to promote, firstly, to respect privacy of individuals, but you cannot hinder access to information. You cannot hinder access to information, and you will see there, nowhere is it highlighted there that you don't have access to information. I think what's important on that page, especially in the long title, is the section that's been highlighted, unsolicited electronic communication, and then personal information across the borders, unlawful collection, and at the bottom there, things like removal of unnecessary impediments to the free flow of information, and so on. So this is what we're going to shall I say, discuss when we look at the other parts. But it's important to understand the spirit of what the intention is of this Act. So on page 4, there are the chapters, and I'll tell you why I'm going to refer to this, or why I'm referring to it. It goes from chapter 1. We'll deal with the definitions and purpose. We actually dealt with it already in Advocate Maake's presentation. It goes on to chapter 2, chapter 3. There are several conditions, the 8 conditions that Advocate Maake referred to. So let us just look at it again. This is in the table of contents. So chapter 3 says the conditions for lawful processing of personal information. And you can see there is condition 1, accountability is dealt with. Condition 2, processing limitation is dealt with in more detail. Condition 3, purpose specification. Condition 4, further processing limitation. Condition 5, information quality. Condition 6, openness. Condition 7, security safeguards. Condition 8, data subject participation. The Act deals with that, and also in those sections. So further on, it goes to a part B, and then part C. There's chapter 4, chapter 5. Now I stopped, and for today's discussion, we can't go through the whole document, so I stopped highlighting areas of discussion at section 38. Section 38. was the last area that I thought is of, great importance to us in our daily, daily our work functions. The rest from section 38 or chapter 5 deals with supervision, as you can see there, chapter 5, but it has got a lot to do with the information regulator and the internal workings of the information regulator, how you approach the information regulator. So we're not going to deal with that. You will see also then it goes on to chapter 6, prior authorization. That maybe has an impact on us. And then also chapter 7, the codes of conduct. The codes of conduct, and Maake, maybe you can also come in. The codes of conduct refers to is it notices and regulations that's brought in on the occasion when they want to adapt, make certain adaptations or whatever.
No,
You can.
yeah, code of conducts are like any other code of conducts to regulate how we as the sector are going to be performing our duties when working for such institutions, and what is it that will be drawn upon from us doing. So it is like a normal code of conduct which deals with do's and don'ts.
Thank you. And then chapter 9, chapter 10, 11, and 12. Now I'm highlighting that just to say that you can read further from there, but we will stop at section 58. And in this document, it's I think page 48. Okay. So let us go to just to page through there on page 12. You'll see there are the definitions and purpose of various words and terms that's being used on page 12. And it's important just to, I'm not going to go through them, but it's important to understand what's meant by a child, for example. Okay, officially, as in officially, and how it's handled in this document. Also, de-identify as something that's important. De-identify, and there's nothing else that I actually want to highlight here. The difference between personal information and further on special personal information. I think that's important in terms of this. So I will now start at on page 16 or section 2 of this of the act. That's where we will start. Section 2 of this document. Now let me just explain what will happen now. The floor is now open for questions. The floor is now open for questions. We will refer to those highlighted parts only, otherwise it takes too long. Only to the highlighted part, to ease the flow of our work, and you may interrupt at any time. And if there's something that you don't understand, Maake is here to assist in the interpretation of that. Or if you have got a question that's related to it, okay, because we're going to go over it quite fast. So maybe we will say, look, let us just hang on, let us just read what it says. But the thing I want to say again, those things were highlighted by me in order to promote the flow, of our work functions. Advocate Maake, you can also obviously interject where you think things need to be highlighted. Okay, so firstly, the purpose of the act there is to give effect to the constitutional right to privacy by safeguarding personal information when processed by a responsible party, subject to justifiable limitations that are aimed at balancing the right to privacy. And then you will see in paragraph B, to regulate the manner in which the personal information may be processed. And then in paragraph C, to provide persons with rights and remedies to protect their personal information from processing. So I think that is the act, okay, to protect and also to regulate private information of individuals. and summarized in those few sentences. We will move on to section 3. We're going to jump to those two subsections, so you need to ask questions. Let me just say, because there's a lot there that must be taken. You may go. Yes.
So can I just ask the member what
Yes.
is still in terms of the question? So we're not having a general discussion on the presentation that the Maake made.
Yes, you can.
So we can ask questions.
At any time. At any time. I will tell you, because I'll tell you why. Because we've got a very specialist person who can now help us interpret the actual what's written here. You see, when he's not with, so that we are empowered to implement this. So what we can do, if we even if it just pertains to something, okay, and then you can also, you can see, well, we won't cover everything. By the way, we won't miss out on anything. If you've got another question, you just want to intercept whether it's got to do with anything that is not there, then you may. Okay, so we just want to run through this document to empower ourselves how to use. So if you have a question already, then you can ask.
Okay,
So yes, you
go
may.
ahead and
Yes, because we're not dealt with the purpose of the. So please go ahead.
And I'm assuming for the recording, we'll actually introduce ourselves too. So I'm Wayne Florence, I'm the Director of Research and Exhibitions at Iziko. And at Maake, I know we did have a discussion about this during the tea break, but I think maybe it's perhaps important for everybody here to also understand the answer to the question, but also for the viewers and the so in terms of the protection of data subjects, I was just wondering what the protection, what protection is actually afforded to non-living data subjects or their descendants and community or communities that they come from. I'm thinking about this specifically in the case of using historical information towards exhibitions of people that are no longer living, that represent communities. So in terms of this act, what protections are actually afforded and how far does that protection extend? And then I have a second question, but I don't know if it's okay if I ask it now.
Maybe let's address that one and then we can then go to the second question. Okay, similar to your question, the people online, they also requested to find out about whether historical data applies to only living persons, etc., etc. And to come to you, I will then combine the two into one. If you go to page 14, the first part there, the legislation is clear that personal information that we're talking about is for people, living persons. You can see living there at the end on the first line. Therefore, that means that for personal information of people who are deceased or no longer living, this act does not apply to them. However, we spoke about code of conduct earlier. Then we can talk about issues of ethics, talk about issues of morals, etc., etc. Based on those, it is courteous that for people who are no longer living, we give them that courtesy not to expose them further in any other way. The example I made was that of Sarah Patman to say we as heritage workers, we have to mount exhibitions about such persons, and in whatever information that we will be sharing with our clients, we must just ensure that anything else that is written about that person is not derogatory, discriminate, etc., etc. But then, as it is, it may happen that we know some of Sarah Batman's descendants. As a way of courtesy, we can inform them that in Iziko will be having an edition of on Sarah Batman, and this is outlook, etc., etc., etc. Just as courtesy, but this act primarily deals with you and me, like as we are living now. To say our personal information must be handled responsibly, but being courteous, it means that for those who are already gone, you must also try as much as you can not to violate them or violate them. Okay, so that answers that first part. Then maybe we can go to the second question you
The
have.
second question is a bit of a process question. So it doesn't require a long answer.
Okay.
And it's a legal question about how you actually do that. Not all of us are legal scholars, and so there may be a particular type of grammar that is acceptable to legal scholars. They're not known to the lay person. So if you just go to the first page of the act and to the preamble, the section that Mr. Arnold has highlighted in that first paragraph that is unlawful collection. In the preamble.
Okay.
So in terms of that word unlawful, there is an adjective, right? And so does it apply to the subsequent words collection? Does it apply to retention? Does it apply to discrimination? And does it apply to the use of personal information? Or is it only referring to the word collection?
Good question.
Okay, there's an answer.
My question is related to this, and I asked here, what are the parameters of unlawful collection? And what are we required to do where we have personal information, but we don't know the source or origin of that information?
Okay. Sure, this is a difficult one. Okay, my understanding here is that okay. Remember when that example of mine when I was entering here, I filled in form and everything. Is that the responsible party does not need to ask me unnecessary questions, and when the collection of the information that they are requiring from me must be for local purposes. They cannot be requesting information from me, which then maybe what we can say will incriminate me, those kind of things. So here they're saying that we have a right to be protected against unlawful collection of information. But then this unlawful collection of information extends to whereby that information that is collected from me can be used for any other purposes that are not attached to why that information was asked of me. Maybe now we can come to you when in instances that you don't know the origin of that personal information. Normally, my colleague here indicated that is from research. You'll know that what normally happens or in scholarly works, we'll have a footnote whereby we are having disclaimers and footnotes whereby we indicate that you must remember that as heritage institutions, and because we're dealing with research mostly, the Act says that Section 14 we deal with the research, is that if the source of information is unknown, then already ethically it becomes a problem for you to use such information because you don't know whether that information is it correct, is it it will be plagiarized as you go on, but is that information factually correct for you to put that bold statement to say Dennis Maake was probably a thief because that puts me in a bad light. Without having supporting documents. That's why when on section 7, the Act deals with issues of liberty, literary and artistic purposes, and then you know that newspapers or poems, they will recite this poem and sometimes insult you or not, or put in good light, sometimes belittle you and all those things. And it is said that they have a poetic license. But then within that poetic license, there are limits. You can't do anything that will like diminish my status or something that will put down any other person. So it is said that if you have information, that's why now we can come back to law. In law, they will say it is alleged that Sophie Brain was the leader of the march, because that information you don't have in person. But if you know the 1956 march, you're sure that Sophie Brain was there, and then when she got the order from the president, it's written there that why did she receive this order? There is documentary evidence or proof that Sophie Brain was one of the leaders. Then there you know that you can come out boldly in big letters to say this is the information. So you need to like just have circumspect when dealing with untrustworthy information, because sometimes one can actually try to make a statement only to find that that person is causing more damage to whatever has been put to the floor.
Sorry, may I just make a comment on your question? I think the adjective refers to all those nouns, because there's nothing wrong with disseminating or storing the information. It's if that is done unlawfully.
Yes, it must be lawful. Yes, also the 8 conditions must apply in everything that we are doing.
Yeah. Thank you. I just want to ask maybe 1 or 2 questions on my part. First, I just want to know, does a photograph on its own constitute what is the bed with special information? Is a photograph with information? Because that's very important for me in my context. Whether a photograph on its own, a photograph about you, but without having the detailed, specific information about you, does that constitute personal information, or it is, I think outlined here in the text. Personal information in the context of photograph, a photograph with information, or if I have just a photograph about you or of you, taken photograph of you, will that then fall within the description, the definition of personal information here? And my second question is, what happens then, because you made reference to data subjects who should be involved in the installation or any exhibition about them. So what happens then in an instance where, for example, those data subjects were not involved in an exhibition about them, those leading, data subjects? So what happens then in that context? And my last question is around in a unionized environment, where certain specific information is required by a recognized union in the workplace now. We made, I think, a very relevant example is the issue of wages, salary increments. Now, if then the union requires information with regards to the specific, issue around salaries. So will that be then, improper of that recognized as structure to request more information from the employer? Then what happens then if the employer then refuses to give that information? Will that be, contemplated, for example, as creating a hostile or prolonging a hostile environment in the workplace? And, what does the act say with regards to a minimum environment when certain information is being required? For example, to deal with the impasse or to deal with a certain situation.
Okay, to start with the first question of a photograph, I think that definition indicates that where it says here, and where it is applicable and identifiable existing touristic person. So identifiable may include the photograph. Then on the issue of unions, I was trying to get to that section. There is a section dealing on how union issues are handled